Welcome to the 6th episode of AI Watch. I'm Michael Munk. In today's episode, we will be listening to Niels Christian Ellegaard's view on how the EU AI Act might affect you if you're considering to use AI, if you are using AI, and how that impact your business and your organization. Niels Christian is a IT attorney and have served as the chairman of the board for the Association of Danish IT Attorneys. So if you're interested in the impact of the EU AI Act on your business, on your organization, stay tuned and keep watching.
Hi, my name is Clara, and I'm a project manager here at 2021 AI in our governance team.
And my name is Niels Christian Ellegaard with the law firm of Plesner. I'm working with IT and focusing also on AI. I've written a book about AI focusing on legal tech back in 2019.
So earlier this year, in June, the EU AI Act was approved by the European Commission. But maybe can you give us a so to say timeline up until this point where we're at right now?
Yes, it's been a long journey. We got some white papers back in the 10th, and then in 2021 we got the EU AI Act first text, and it's then been through a number of committees, and as you mentioned just recently, the new adopted text was approved by the European Parliament here in June. And we expect that the final text will be adopted by the Council end of this year, and then there will be a 2-year implementation period in 24 and 25, and then 1st of January 26 it will probably enter into force if we follow the schedule as it looks now.
But else maybe you could give us a high-level explanation of the EU AI Act framework.
Yeah, basically the EU Act is dividing the AI systems into 3 buckets. So they talk about prohibited systems, high-risk systems, and then we have what we could call the ordinary systems. Prohibited systems are like, for instance, social scoring and manipulative systems. They are entirely prohibited, so you can't use them in EU, whereas high-risk systems are allowed as long as you comply with the requirements, which are quite comprehensive. And then you have the ordinary systems, which are subject to, you can say, a limited number of requirements about transparency, for instance. It establishes the full supply chain within AI systems, but mainly it's focusing on the providers, namely say you need to be doing a conformity assessment and you need to have a risk management system in place.
So now you mentioned high-risk systems. Just to give some examples of what a high-risk system is compared to the prohibited or the medium risk, for instance.
Yeah, the way that it's dealt with, and I've brought the act here really, is that you can say the high-risk systems is really a set of systems, and it's focusing very much on social interaction. Just to give you some example, is education and vocational training, employment, workers management, access to social benefits, credit scoring and the like, law enforcement, asylum, and also administration of justice. You may ask, how about AI systems for medical purposes? And that is not covered. And probably the reason why is that has to be dealt with through some other regulations. So you shouldn't see this list as exhaustive in the sense that AI systems may be addressed by other regulations. One peculiar thing, maybe not so peculiar, but is that in terms of scope, AI systems used exclusively for military purposes, they are entirely excluded from scope here. Also, where you look at the administration of justice and democratic processes, where you have defined high-risk systems for the use by courts to assess facts and law. That use case does not comprise the use of similar systems by lawyers. So we may end up in a situation where lawyers are actually enabled to use this system without it being categorized as a high-risk system, whereas judges cannot use those systems without this being provided as a high-risk system. And that could have the consequence eventually that the providers, they will not take the hassle of going through all the compliance burdens and then only make it available to lawyers. So we could end up eventually, as I say, in a situation where courts are not having the same tools as the lawyers. So they are put in a very poor position if AI gets that traction as we see today.
Now, with LLMs and generative AI and so on, in your opinion, how has that changed the EU AI Act?
That has changed that has changed it a lot, because if you look at the definition of what is an AI system, really, in the first or in the outset, it was defined through the techniques applied. So now we have a whole new definition of what constitutes an AI system, which means that it's not so much focused on the techniques, but rather on a more abstract and generic definition of whether the system is acting with a certain level of autonomy.
In terms of the main objectives of the EU AI Act, could you give us some insights into that, just on a high level?
Yeah, the main objective really of the EU AI Act is to mitigate the risks of using AI systems. And the way you do that is to enforce compliance obligations on the whole supply chain. And all of these obligations, they apply to high-risk systems only. So if you have an ordinary system not on the list of high-risk systems, you only are subject to a few transparency requirements, basically.
So maybe you could give some insights into the actual application of the Act?
Yeah. I think the best way to go forward is to say what kind of systems are on the list of high-risk systems, which is really the objective to hit those systems with requirements. So a good example of that is credit scoring, where you can say banks and other credit institutions using AI to credit score natural persons. You need to be able to document that you have used the right data and so on. And you also have to apply human oversight, meaning that if you are or me are subject to credit scoring, then you need to, in any given situation, be able to make this a human decision rather than a machine decision.
To wrap this episode up a bit, what would be the 3 key takeaways for companies to think about?
Yeah, I think the first takeaway is to find out what kind of system am I dealing with here. Is it a prohibited system, or will it be a prohibited system, or will it be a high-risk system, or just an ordinary system? And of course, this may change over time, but you need to find out where am I in this area. Second is if it's a high-risk system, the obligations that will rest upon you, will you be able to meet those requirements, and do you need to do something now? And you can say the third element is if you figure out whatever I do now, will I then be likely to meet those requirements in let's say 1st of January 2026 when it applies effectively. So these would be my focus areas if I was dealing personally with an AI system, to make sure that I don't invest in something which is later down the road either prohibited or which is very difficult for me to account for under the EU AI Act.
So thank you so much for watching, and thank you, Niels, for participating in such an interesting discussion, and see you next time.
We hope that you enjoyed this episode of AI Watch. As always, please leave comments, especially this time if there's anything in what you've seen today presented from Niels Christian that you disagree with, that you do agree with, that you want us to extrapolate, do more of, please come forward. Please also remember to sign up so you don't miss the next episode of AI Watch. Thank you.